What if I told you that a rejected insurance claim doesn't always stay rejected? And that some insurance claims that are initially rejected eventually get paid? Many policyholders receive a denial letter and assume the case is closed. But what if the insurer's decision isn't the final word? In this video, you'll learn the 3 critical steps you can take to challenge a denied claim in Kenya, how the insurance regulatory authority can help, and the legal avenue that could ultimately force an insurer to pay. Most importantly, you'll discover the costly mistake that causes many valid appeals to fail. Before you give up on a rejected claim, watch this video to the end. The information you're about to learn could save you thousands and protect your rights as a policyholder. Hello, and welcome to Insurance World TV, your premier insurance education channel. If you are new here, this channel is dedicated to simplifying insurance, financial protection, and real-life risk management in a way that is practical, relatable, and easy to understand. We break down complex insurance concepts into clear, everyday language so that you can make better financial decisions, protect your family, and understand your rights as a policyholder. Today, we are tackling one of the most important and misunderstood topics in insurance. What happens when your insurance claim is rejected? For many people, this is where confusion, frustration, and helplessness begin. But as you will learn in this video, a rejected claim is not always the end of the road. In fact, it is often the beginning of a structured legal and regulatory process that gives you the right to challenge that decision. So, stay with me as we break this down step by step. The claim rejection reality. Every year in Kenya, thousands of people receive one of the most frustrating messages they can encounter after suffering a loss. Your insurance claim has been rejected. For many policyholders, this moment feels final. It feels like the system has closed its doors and there is nothing more that can be done. But in reality, that assumption is not correct. A rejected insurance claim is not necessarily the end of the road. In fact, it is often the beginning of a structured legal and regulatory process designed specifically to protect policyholders. In Kenya, insurance disputes are not left to the insurer alone. There is a clear escalation path that ensures fairness, accountability, and independent review. This process involves 3 key stages: the insurer's internal appeal process, the Insurance Regulatory Authority, IRA, and finally the Insurance Appeals Tribunal. Understanding this process can completely change how you respond to a claim rejection. Instead of accepting it immediately, you can challenge it systematically and professionally. But before we get into the steps, it is important to understand why claims are rejected in the first place. Reasons why insurance claims get rejected. Insurance claims are not always denied unfairly. In many cases, rejections are based on technical or procedural issues. Some of the most common reasons include missing documentation, late reporting of the incident, or specific policy exclusions that many policyholders may not have fully understood at the time of purchase. There are also cases where disputes arise over the cause of loss or the interpretation of policy terms. Insurance contracts are legal documents, and sometimes disagreements come down to interpretation rather than intention. However, there are also situations where claims are rejected unfairly or without sufficient justification. This is where the appeal process becomes critical. In Kenya, policyholders are protected by regulation. You have the right to receive a written explanation for any claim denial. You also have the right to challenge that decision and escalate it if necessary. In Kenya, a denied insurance claim isn't the end of the road. Policyholders can challenge a claim denial through a structured appeals process. If the insurer still refuses, escalate from the insurer's internal review to a written complaint with the Insurance Regulatory Authority, IRA, and ultimately to the Statutory Insurance Appeals Tribunal. The three-step process below outlines your options. Step 1. Insurer Internal Appeal. The first and most important step is the internal appeal process with the insurer. Lodge a written complaint with your insurer through the customer service or complaints office, detailing policy numbers, claim facts and decision, and requested remedy. This is your opportunity to ask the insurance company to review its own decision. It is not a court process, and it does not involve regulators at this stage. It is a formal request for reconsideration based on additional evidence or clarification. To do this effectively, you must submit a written appeal supported by complete documentation, which includes your insurance policy, claim forms, the official denial letter, police abstracts, medical reports, repair invoices, photographs, receipts, and any other supporting evidence. At this stage, presentation matters. A well-organized file significantly improves your chances of success. Remember to have your correspondences acknowledged by either having the original copies stamped by the insurance company for hard copies or an acknowledgement email for soft copies. Keep copies of all correspondences for future reference. Insurers typically respond within a few weeks, often 2 to 4 weeks, so follow up if you don't hear back within about 30 days. When insurers receive an appeal against a denied claim, they review the case and either rescind the denial and proceed to process payment or uphold their original decision. In many cases, insurers do reverse their decisions during internal review when strong evidence is provided. However, if the insurer upholds the rejection or fails to respond within a reasonable time, then the matter can be escalated, as outlined in Step 2. Step 2. Lodge an IRA complaint. The second stage is filing a complaint with the Insurance Regulatory Authority, commonly known as the IRA. If the insurer refuses to change its decision, your next step is to escalate the matter to the IRA. This is where the dispute becomes formal and moves into an independent regulatory review process. The IRA is mandated under the Insurance Act to regulate the insurance industry and to protect the interests of policyholders. Under the law, insurers are required to admit or deny claims and settle valid claims within the prescribed timelines after notification. Failure to do so, or unjustified delays in claims handling, may be treated as poor claims practice and can attract regulatory intervention. When an insurer denies or delays a claim without sufficient justification, the matter can be escalated to the IRA for review. In such cases, the IRA treats the complaint as a potential breach of fair market conduct and may investigate the insurer's handling of the claim. By law, the Commissioner is required to receive and consider written complaints from policyholders and issue a determination after reviewing the evidence submitted by both parties. These determinations are binding on both the insurer and the policyholder, unless further appealed. To initiate this process, you must submit a formal complaint supported by all relevant documentation. This includes your insurance policy, claim documents, the denial letter, internal appeal correspondence, and any supporting evidence such as reports, receipts, or photographs. Once received, the IRA reviews the case, may request additional information, and investigates the insurer's conduct. Where appropriate, it may also facilitate mediation between the parties to reach a fair resolution. In many cases, disputes are resolved at this stage without the need for further escalation. However, if you are still dissatisfied with the outcome, there remains one final avenue of appeal. Step 3. Insurance Appeals Tribunal. If you are not satisfied with the decision made by the Insurance Regulatory Authority, your final avenue of appeal is the Insurance Appeals Tribunal. What is the Insurance Appeals Tribunal? The Insurance Appeals Tribunal in Kenya is a specialized quasi-judicial body established under the Insurance Act to hear and determine disputes arising within the insurance sector. It provides policyholders, insurers, brokers, agents, and other stakeholders with an affordable, independent, and expert alternative to the traditional court system when challenging insurance-related decisions. The tribunal plays a critical role in ensuring fairness and accountability by reviewing disputes that cannot be resolved through insurers or the Insurance Regulatory Authority. Its key functions include hearing appeals involving the following. Number 1. Unfair claim rejections or delayed claim settlements. Number 2. Decisions and rulings made by the Insurance Regulatory Authority. Number 3. Disputes involving insurance brokers, agents, and underwriting commissions. Number 4. Complaints relating to unclear, misleading, or disputed policy terms and conditions. In essence, the Insurance Appeals Tribunal serves as a final specialized forum for resolving insurance disputes, ensuring that policyholders and other industry participants have access to justice when they believe a decision has been made unfairly. At this stage, the dispute becomes formal legal adjudication. Evidence is carefully reviewed, legal arguments are considered, and both the insurer and the policyholder may be heard before a determination is made. One critical rule applies at this level. You must file your appeal within 30 days of the IRA decision. Missing this deadline may result in losing the right to pursue the matter further. The tribunal has the authority to either uphold or overturn the decision made by the IRA. It can also order the insurer to settle a valid claim where appropriate. In some cases, the tribunal may go further and award legal costs or compensation depending on the circumstances of the dispute. This makes the Insurance Appeals Tribunal the strongest and final formal avenue for resolving insurance claim disputes in Kenya. Possible outcomes of an appeal of denied claims. When you lodge an appeal at any of the 3 stages we have discussed, there are generally two possible outcomes. The first is that the decision is overturned. This means the reviewing body finds merit in your appeal and reverses the original decision, which may result in your claim being approved and paid. The second is that the decision is upheld. In this case, the reviewing body agrees with the original decision and determines that the claim was correctly denied based on the policy terms, available evidence, or applicable regulations. Ultimately, the outcome will depend on the strength of the evidence, the facts of the case, and whether the original decision was consistent with the policy and the law. If your appeal is successful, several positive outcomes are possible depending on the facts of the case and the stage at which the dispute is resolved. The most common outcome is that the insurer reverses its decision and proceeds to pay the claim either in full or in accordance with the policy terms. In cases where there has been an unreasonable delay in settlement, the policyholder may also be entitled to interest on the claim amount. Where the dispute progresses to the tribunal, the successful party may, in certain circumstances, be awarded legal costs or other forms of compensation. It is also possible for the appeal process to result in a negotiated settlement between the insurer and the policyholder, avoiding lengthy legal proceedings. The key takeaway is that a denied claim does not always mean a lost claim. An appeal provides an opportunity for the decision to be reviewed, corrected, and, where justified, overturned. This is why policyholders should never assume that a claim rejection is the final word on the matter. Common mistakes to avoid when making a claim. Many valid claims fail, not because they are invalid, but because of avoidable mistakes. These include missing deadlines, submitting incomplete documentation, relying on informal communication instead of written appeals, or failing to escalate when required. Insurance disputes are not only about facts. They are also about process. Procedure matters just as much as evidence. In conclusion, a rejected insurance claim is not the end of your rights. In Kenya, there is a structured system designed to ensure fairness and accountability. First, you appeal to the insurer. If that fails, you escalate to the insurance regulatory authority. And, if necessary, you proceed to the insurance appeals tribunal. This system exists to protect you, but only if you understand it and use it correctly. So the next time you hear the words, "Your claim has been rejected," remember this: you are not at the end of the process. You are simply at the beginning of a structured journey toward resolution. And with the right knowledge, documentation, and persistence, that journey can still lead to a fair outcome. That brings us to the end of today's lesson on how to appeal a denied insurance claim in Kenya. As we've seen, a claim rejection does not necessarily mean the end of your case. By understanding the proper appeal process, from the insurer's internal review to the insurance regulatory authority and ultimately the insurance appeals tribunal, you can confidently pursue a fair outcome and protect your rights as a policyholder. Thank you for watching Insurance World TV. If you found this video helpful, please like, share, and subscribe for more practical insights on insurance, risk management, and financial protection. Until next time, stay informed, stay protected, and always understand your rights. God bless you, and see you in the next video.